All right, welcome everybody to another edition of Legal Tech Week. It is January 27th, 2023, and this is the show where we talk about the latest developments in legal tech and legal innovation. I am Bob Ambrogi. I have the blog Law Sites and the podcast Law Next and the legal tech directory Law Next. And we've some of our usual panelists are here this week, some aren't, but we have a special guest panelist. So I'll let him introduce himself first. Greg, say hello.
Sure. I'm Greg Lambert. I'm the Chief Knowledge Services Officer at Jackson Walker, and Bob was making fun that I showed up branded with the firm logo. And then on the side, I also run the Three Geeks in a Law blog, as well as the Geek in Review podcast alongside with Marlene Gaybauer.
And some of our usual suspects here this week. Stephanie Wilkins, you want to say hello?
Yes, if I can unmute myself. Hi, I'm Stephanie Wilkins. I'm the editor-in-chief of Legal Tech News at ALM.
And Victor.
Hi, everyone. Victor Lee, Assistant Managing Editor with the ABA Journal, focusing on business of law and technology.
And last but not least, Steve.
Hey, Steve Embry. I write the blog Tech Law Crossroads about legal innovation and technology, and I'm also the current chair of the Law Practice Division of the ABA.
So it's been an interesting week in a lot of ways. There's been a lot of interesting stuff that's happened this week, and we'll try to get to a lot of it. But I always like to give first up privilege to our guests, and we have a guest panelist. And Greg, you've done a few interesting things this week yourself. So you want to tell us about that?
Yeah. So I've been, I guess, like the rest of the world, have been playing around with the OpenAI tool. Started off with the Chat GPT.
We have to pull Stephanie away from it just to get her on this show. It's enough we can do.
It's quite addictive.
I wish that was a joke.
It's the new Tetris. So
Yeah,
you just can't. But I started a few weeks ago playing with the paid version with the beta on the GPT 3.5. And I say it's a paid version, which means you have to give your credit card in order to get access to it. Although I think they give you an $18 kind of play money to deal with it. But it's really fairly inexpensive. About every search I do is a penny or less. And so it's definitely worth the money to invest in just, as the common advice is, just give up one latte a week and you'll be able to pay for this with, and save $1 million by the time you retire.
You get what you pay for.
But as a law librarian, one of the things that we have to deal with is just tons of information that comes in. And, we have approximately, if you're lucky, you have about one librarian or researcher per 50 attorneys, but typically it's more like 75 to 150 attorneys. And so your time is very valuable, and we are asked to do a lot of, reading, looking, summarizing a number of things, setting up alerts. And so I thought the best thing to do would be to take a look at some of the alerts that we set up and see if there's a better way to present those. And unlike the conversation that we've heard, that we've been caught up with on Twitter this week, with asking it, to go out and find and create a summary based on a legal issue, what I've done is taken articles and had those articles summarized by the AI. So you might take a 1 page or a 5 or 10 paragraph article, and it will come back with a 1 paragraph summary, and it's really good at doing that and coming back with some of the highlights on that. And so I played around with that in order to determine ways that, if we're doing a search on Jackson Walker in the news, instead of just giving them a link in the first paragraph or the keywords in context part of it, why not use the AI to do a summary of it and have it make sense whether or not it's something that someone wants to read. And of course, I couldn't just stop there. So we could do that on our portal page and get out really good information, allow attorneys to track or other legal professionals to track the information that they want. But I thought, I like listening to podcasts. So how about taking it to the next level and taking that summary and putting it into giving it an artificial voice and then uploading that into a podcast. So that's what I've been working with. I put a blog post out on the 23rd talking about the steps that I took. And it's not easy. I'm an old programmer from back in the day, but I had to learn a few new things in Python to automate the process. But I worked with it. I got that. There's a program called the Script that will translate it from text to voice. And then I use Anchor, which is free. So basically, except for the small amount that I'm paying for the GPT engine to summarize the article, it's basically all free. So I would say for each podcast I put out, it's cost me less than 10 cents. And it's probably taken me about 5 minutes to get it all set up, because there are still some things that are that you have to do, but it's been pretty good. I'm gonna put a link. Oops, no,
I linked to your post, but
yeah, and I'm gonna put a link to the podcast that I've been playing with. I haven't been advertising it, but I got one, two, I think I have 3 days out of legal text summaries. And I was teasing Bob, the AI is pretty good, except it refers to Bob as Bob Ambrogi. So I've got to upgrade the audio on that in the voice.
a lot of my friends do that too.
Maybe it's right, and Bob's been wrong the whole time.
Yeah.
That is totally possible. So does this mean Marlene's out of a job as your co-host? You just
Oh no, but she was sick this week, so I actually had to be solo with our interview that's coming out next week. So, but it's a good stand-in in case one of us goes down. But it's actually really I've just been having so much fun doing this, and one of the things, and I think a lot of people get tied up in the nuance of the AI tool about, well, it can't do this, it can't do this. And it's like, well, no, and it's not trained to do that. But what it is trained on is, and some of the things, like, it helped me a lot with setting up the programming. I could ask it to write a Python script that it did X, Y, and Z. And it wasn't perfect, but it was a lot better than me going and scouring Google and trying to figure it out, or watching YouTube and hoping that I could find somebody that was kind enough to put an example out on the web for me. And then the summaries, again, you're giving it something to summarize, to analyze, rather than asking it to just, take this database that you have and then, hopefully you'll come up with what I want. So I laughed when I was when I was an undergrad. I had someone tell me the computers were the dumbest thing on campus because they only did exactly what you told them to do. And I think in a way, some of the AI is exactly that. It will only do exactly what you're asking it to do. And I think the creativity, this part of this type of AI, is that it does go beyond that. And as a guest I had on a few weeks ago, Ashley Carlisle from Hyperdraft AI, she goes, whatever it comes back with, it is very confident in its answer. And so it's confident enough to fool most people into thinking that it's true, when really, as we found out this week with some of the things that Mark did with the Illinois bar, is that it just makes stuff up. But it sounds very, it takes that and puts it in a way that is very, very confident, and it can fool people.
Yeah. If you didn't see Mark's posts on Twitter, I think they were, and talking about the fact that he asked for some funny cases about something. I don't even remember now what it was. Mark is probably in the audience here, but it it answered him and gave him some cases. Turned out they
Mhm.
weren't real cases, but it basically made
But they
up
were
the
on
cases.
point. They
They
were
were on
definitely
point.
on point.
It
Really, that's
reminds-
all you want as a lawyer, right?
It
I mean,
reminds
what
me
judge
of
is
what
ever going to check the case anyway?
reminds me of what we used to say about one of my partners. He may be wrong, but he's never uncertain.
Right, right.
I'm curious about the paid version. What do you see as the difference? Is it just speed, or is there any other notable difference?
Well, the biggest difference is that I'm almost never locked out of it. It's never too busy. But the types of engines that it's running in the background are more high level,
Okay.
and you get a little bit more flexibility with it. But for what most people do, I think the Chat GPT version works really, really well, as long as you're not asking it to, kind of create something that you would rely upon
Sure.
without having to check it.
Got it.
Yeah.
Yeah, I think-
And
I
I
think-
also think that the paid version, there's a way that you can train it on some of you can train it on some of your own information as well. So I have not done that, but I talked with some friends of mine that are at Yale, and that's one of the things that they're planning on doing, is to giving it some things to fine tune it by giving it some additional information to work with.
So how long did that initial setup take you when you did it for your podcast?
Well, it probably took about 10 hours, but because, I mean, that was start to scratch. Me trying to relearn Python was probably 8 hours of that. And then I spent a couple, the last couple of hours was trying to tweak it to make sure I was asking it the right way. I was getting the right information to feed to it. And so there's, but now literally right before I jumped on, I've got everything set up to go, and it took me about 5 minutes to get a show set up, and it's got 6 summaries. So it's about a minute per summary. So I've got a 6-minute podcast ready to go out. It took me about 5 minutes to do it.
It's awesome. So from a AI in law success story to an AI in law disaster story this week, maybe, or at least a robots in law disaster story. We have the sad tale of Do Not Pay. Stephanie, I know you guys covered that. You want to
Yeah.
talk about that a little bit?
Better yet, do not work.
Do not work.
Yeah.
I love that. Yeah.
Do not practice.
Do not
Yeah.
practice.
Yeah, it's
The
pretty
whole do
ugly.
not thing. I mean, yeah.
I mean, I think I guess I'm assuming everyone knows, but they in case you don't, they proposed the whole basically chatbot in court, chatbot lawyer, robo lawyer in court. Everyone sort of rolled their eyes at it, but then eventually he got official pushback. He got threatened to be put in jail if it happened, which isn't really a surprise because it was a stunt from the beginning. Most people thought that knew anything about how any of that works. But I don't know if it was for that reason that he got on people's radar, but at the same time, people started systematically testing the legal products and just taking them down because they weren't delivering. Either what they delivered was not good, or they just didn't deliver, and it just was a whole Twitter takedown snowball, and it led to them, I feel like within 48 hours, 24 hours, discontinuing all of their legal like non-consumer. There was very weird wording of it, which I'm not sure if it covers all things, but it discontinued all their legal products, and they're working on just consumer protection, things like arguing down bills or things like that, which is kind of where they started. And it's really interesting. There's been a lot of discussion, and I don't really know how I feel. I mean, I think it was hubris. I think it was a stunt that went too far and was his undoing. But I mean, somewhere in there, it all came from a good place, and it was meant to do the access to justice, which we need serious help with. So taking any player out of that game is really concerning, but also I feel like, I mean, you have to do it the right way, but it has raised a ton of questions on that front that I don't know the answer to, and I think people are still working out. And that was sort of just a long monologue there. And I know there's a lot in it. And I know, Bob, you've written and talked about this a lot too.
Yeah, I mean, I wrote about it this week just because I felt like my concern is that suddenly all these people who have been like, especially some people in the organized bar or lawyers who have been kind of opposing the use of tech to advance access to justice are all going to suddenly grab onto this and say, see, we told you so. These people are going to screw consumers, and that's why you need lawyers. And and of course, this is just a horribly aberrant example. And there's so many great examples of tech being used to serve consumers out there. I mean, we could just go down a long list of things. It is really, so much about it is really confusing, because I mean, the idea that Browder ever thought he was going to get away with this whole going into court thing with somebody wearing AirPods and standing in front of a judge. I mean, as I said in my piece, I've been before a lot of judges, and there's not one who's going to stand there and watch me with AirPods in my ear while I wait for somebody to tell me what to say next. I mean, that ain't going to happen, and they're not going to let me wear the AirPods in the first place. And it's this whole thing about, they told me I might get prosecuted. Well, what did he think might happen if he did that? I mean, did he just think nothing was going to happen?
I mean, I don't think he thought about it personally. Like, I haven't obviously asked him, but he's not a law guy. He's a tech guy, and it's just about pushing the boundaries of the tech. But when you get in the access to justice space in particular, where people that really need it the most, you don't stop to think about if you can get away with it. You're like, look at look at the cool thing my tech can do, but like, there's real people at stake. And I think that's where he went too far, too fast. The tweet, the bragging about it too, was the complete undoing. The $1 million for SCOTUS was just like, I've been saying hubris. I've been saying it's, Icarus flying too close to the sun. And it undid a lot of good work that could have been done. And I'm afraid it's going to have a bigger impact on other people who are doing good work. And I know he himself raised the protectionism point. He tried to spin it as, this is just the legal profession protectionism, trying to keep other people out of their club. And I'm like, no, you still have to do it right.
Right.
Like, you can't just fall in that. That is true. And that is an issue that needs to be discussed. But this is not the poster child for that, in my opinion.
One of the things
let's be honest, right?
Yeah, go ahead, Victor.
Sorry. But let's be honest, right? I mean, we've all, I think most of us have interviewed Browder at some point. Most of us have talked to him. I mean, I like him, but like, we know that he does have some hubris in him, and he does have that little bit of arrogance, which I think you need if you're gonna be in this space and like challenge, established protocols and whatnot. You need a little bit of that arrogance in you. But obviously, I mean, this whole idea of like, oh well, I was told like that this would be unauthorized practice of law. Well, yeah, I mean, and they've been telling you this from the beginning, even from when your product first came out, when it was just limited to tickets. I mean, people have been telling you this for years, and so I do wonder if a lot of it was just this idea of, hey, look at the cool thing my tech can do. You're not going to see it happen because of these backwards people who are afraid of me. But look at this cool thing my tech can do, and look at other things that I think that I can do if I put my mind to it. So I think we've all kind of known that because it seemed like he did this a lot, where it was like something would happen, and then some scandal would happen, or some bank would like have some kind of issue. I don't know if it was Wells Fargo or something. He'd be like, oh, well, my app can help you get money back from these people. Or, something else would happen. He'd be like, oh, my app can now do this and do this and do this. And it's just like, you always kind of felt like he was kind of chasing that next big thing. And I kind of wonder if this was the one thing that kind of got a little too big for him.
Yeah, I think he missed a big opportunity. One, he definitely jumped the shark by doing that $1 million, basically a $1 million bounty. But what he should have done was created almost like a challenge, and he could have gotten like the academic world involved in this. They could have set up moot court competitions, or some type of demonstration where he could have literally like had 3 or 4 cases going on, and with real judges doing it on a mock trial basis, not knowing is this information coming to me. Think back to and people may remember the first time a California wine beat a French wine in a world competition. It was a blind test, And if he could have created a blind test that would have allowed, the same, maybe the same set of facts or similar set of facts, one of them, you got 3 people, you got one represented by counsel, one pro se, and one represented with the AI, and they're all got AirPods in, and no one knows who the control group is. So there's lots of opportunity to do something like that. He just couldn't get out of his own way. And I mean, the hubris that he had, and it was, again, Ashley Carlisle that I had on before, she found it just flat out insulting to the legal industry, the way that he was approaching it. Not necessarily that it couldn't work, but the way the stunt he was trying to pull was insulting.
And I think that, like, to go to the discussion that's going on in the comments right now about what would have been the right way to do this, is that I think there's a right way, which is what you're saying. There's a right way to test this and get there. I don't think there currently is a right way to implement this in real life, and they wanted to get there faster than they should. There is no right way to put this tool in court right now. That's not the question. The right way is it's going to take a little bit longer. Like, we want things faster, especially because this has all gone so quickly from the public launch of it, that the right way is to actually sometimes wait a little bit. And it's like, I feel like I've moved on from I always used to go back to the Spider-Man quote, but I feel like I've moved on to the, like, Jeff Goldblum in Jurassic Park quote that is like, the scientists were so preoccupied with whether they could do it that they didn't stop to think if they should. I mean, we want things now, but the right way involves testing, especially when it's legal rights at stake.
And I think I'm more concerned about the lasting impact of the fact that his programs don't work. If you're going to make some kind of outlandish claim and try to say that you could put AirPods on and march into court and all that stuff, at very least you better have a product that's going to work to back it up. Now it looks like all of these access to justice AI programs are just a bunch of hooey, and we got to have lawyers involved forever. And gee, I told you it would never work. It's a bunch of BS, and I think it's kind of a big setback, because it doesn't work.
And that's my big concern, because a lot of these are not hooey and BS. There's a lot of great work being done out there, and they had the spotlight. They had the chance to, put this on the map, and now they've put it on the map. I mean, people are talking about it, which is always a good thing, but they may have put it on the map in very much a wrong way.
Yeah,
I think there was another aspect.
Go ahead, Bob.
No, you could finish.
No, I was just going to say, if he pulled his stunt and his product worked, we might all be sitting around thinking, that was kind of a dumb thing to do, but at least called it attention to a possibility that might happen, and it's not such a bad thing. But combined with the fact that the damn thing doesn't work is a real problem.
Yeah.
Well,
I was just going to say.
Sorry.
Go ahead, Victor.
I was just saying, it's like how those blind taste tests actually ended up helping Coke when they when they came up with a new Coke thing, and it was a total flop and it was a failure. But then it ended up actually, strengthening them in the long run. It's like, so maybe this is actually going to help do that pain in the long run. But then I thought about it, I was like, nah, probably not.
Yeah. The other aspect of this that had me thinking over the last couple of days is how do I put this? It raised questions about legal journalism. I mean, I've covered Josh Broder for years. I had him on my podcast way back in 2018 when he was 21 years old. I've never tried any of his products. I never once went and tested any of his products to see if they actually do what they said they do. And he has gotten so much media attention over the years. And I will say, actually, when he first launched Do Not Pay, I had some lawyer used to be sending me spreadsheets saying that his claims about all the cases they've resolved in Do Not Pay just don't match the numbers. If you go in and look at the docket filings in the UK where he originally launched it, there weren't that many cases, as many as he claimed. I mean, I don't know whether that was true. I was never able to verify it, so I never wrote about it. But I mean, going back to the early days, we were so, some of us, I'm not blaming everybody, but some of us are so, eager to see this kind of technology evolve that we take it at face value. And even his claim this week that he was threatened with prosecution and imprisonment. do we really know that? He's refused. I asked him, he didn't answer me. I saw the NPR piece that he didn't identify any
Right.
prosecutors who've actually done this or said this. I mean, we take an awful lot of stuff at face value. And it's hard sometimes with legal tech. You can't just always go and test everything. And
Mhm.
I wish I had all the time in the world, like Greg does, to go develop things like bots to do his AI to do his podcast. But it's a little bit of a shortcoming around tech journalism and legal tech journalism as well, I think.
Yeah. I don't know if you're referring, there was that one specific tweet after the whole, thread came out that was like, how have no journalists ever tested this before? Like I saw
I
that.
didn't see
and I was
that, but
like,
yeah, did I say that? No, I
Yeah.
didn't see that, but
that somebody said that, and I was like, we were just sort of like, ouch. I mean,
yeah. Yeah. So the
Like you
hero of the
said,
week is
there's-
Catherine Tewson. The
I
woman that
know.
went through and finally did this.
Yeah.
So, what else? I'm trying to think of what else we even had on our agenda this week. So that was such a bizarre development that really, and actually, I think one other before we leave that, one other interesting twist. I felt like it did a lot to revive Twitter this week. there was like incredible activity on Twitter around this, and Twitter's been kind of dormant for a while now. So I don't know if this breathed new life into Twitter or showed that Twitter is still the place to talk about some of this stuff over some of the alternatives out there like Mastodon or Post. Didn't see a lot of activity on Post around it. Anyway. So Victor, I know you had a couple of stories, but you also this week had the Legal Rebels, and that's probably worth a little bit of a mention here. Some tech innovators on that list.
Yes, thank you for reminding me. I knew it came out this week, but like I know it's one of those things where it's dated February 1st, so because that's when the magazine comes out. So I'm like, well, it's not February yet. So
well, we can do it next week.
But it is online, so I was like, all right, well, it's out. So
it's been talked about.
Yeah. So we the ABA Journal and the ABA Center for Innovation picked its usual class of its annual class of Legal Rebels. And this year I thought we had a pretty diverse bunch. I mean, we've been trying to get more diverse people into the mix in general. So this year I thought we had a good mix of not just diversity in terms of like national origin and race and things like that, but also geographic and like they didn't all skew heavily toward one area or another, because in the past we have maybe skewed a little too heavy toward like either criminal justice or access to justice or things like that. So I thought it was a good mix of things this year, and so you can check it out. I posted the link. I posted the link in the chat. You can check it out and look at the individual profiles. The staff pitched in and wrote the profiles on the people and whatnot. And so check it out when you can and let me know what you think.
Yeah, I thought it was a good list. I already tweeted that I thought it's like every time I see the Legal Rebels class comes out, I'm always wondering how those people weren't already on the list from some prior year. Because
we do end up going through that a lot, like in our meetings, sort of like, well, how come we haven't picked this person yet? How can we and so part of it was obviously we're kind of limited to like 8 people a year, so obviously people end up following. I mean, it's not like when Fast Case does like the 50 or when or even I think the Women in Legal Tech one, they usually end up having a longer list than we do, so we're kind of limited because of the space in the magazine, and then also like staffing and whatnot. And so we end up having to kind of limit it every year. And then there are always people that kind of like, there were some people who were like, okay, well, we kind of focused on the issue last year. Do we want to focus the same person or not the same person, but like we want to focus someone who kind of looked at the same issue this time as well, and like do it 2 years in a row, or can we kind of hold off on it until like for another year. And then also I think the last like a few years ago, we tried to do a couple themed issues where it was like one was like court officials who were innovating during COVID. Some of it was like teams of people who work together, and so then that pushed some people to the side because they were like, okay, well, because they didn't fit into one of those constructs. So sometimes it just comes down to stuff like that, and then sometimes we just miss things.
And
And yes, Joshua Browder was
I
a
don't know if
legal.
that's I don't know if that's a little zing or.
No, I wrote that one. I wrote that one. That was the first time I ever spoke to him, actually, because I think that was right after he launched it. So that was when he was still in school. I think it was at Stanford at the time, I think. Yeah, so that was when he was still in school.
Yeah. I mean, I think this is a part of the reason this story is kind of one of the things that makes this story disturbing is we have probably all talked to Joshua at this point, some point or another. And I honestly, I really think he is sincere in his mission to use tech to help consumers resolve common legal or other kinds of problems. You just got to wonder what really happened here. So he was certainly a legal rebel in 2017. And
Well, and I think Colleen earlier in the comments may have spotted it and said, this may be the Elizabeth Holmes of legal tech, in that it's a great idea. It's just that, everything, there was so much going on in the background to make it look like it was working that, it just, and I think they probably thought, or, both Elizabeth Holmes and Joshua probably thought, well, this is something that we can, given enough time and money and expertise, we'll make this work. It's just now we just got to prop it up on the back end in order to make it work.
Yeah, I talked about journalists not doing their due diligence here. What about the investors in this company? I mean, these are some major VCs invested in this company, and did they not do their due diligence into this stuff? I don't understand that.
Well, but let's be honest, right? And I'll play devil's advocate for a minute. I mean, the concept is solid, right? I mean, because this idea of like using, because so much of litigation, regardless of what, I mean, obviously not the really complex litigation, but like, like your small claims courts or even your bankruptcy court, a lot of it is form driven. A lot of it is, wrote, cut and paste, and like, put your name here and put your name there, enter the amount in dispute, and blah blah blah, and then just make sure you file it on time. I mean, a lot of it is just that rote paperwork that makes sure that you file this, this, and it's signed here, and it says this, and it make sure you get it there at the right time. And like, I mean, I know there were other programs that that's not a new concept, but like the idea of kind of taking litigation and breaking it down into like, okay, well, other than like the stuff when you're in court and you're making arguments and you're picking juries and you're doing closings, that kind of stuff, a lot of the stuff that leads into it is stuff that can be done by AI or by a machine or something like that. So,
sure.
I mean, that concept I think is sound, but whether or not, there's I mean, and maybe he's not the best example of this, but I mean, the idea that you can kind of break it down like that, I thought that was a pretty interesting thing that he did.
Sure, and there's other companies out there doing that. Look at like SoloSuit, which is doing that for debt collection cases, where they're simple. All they do is help you prepare the response to the lawsuit, because they found that a lot of people just never even responded to these lawsuits. They're not going into court and defending you or anything else. They're just getting you past that hurdle of filing a response.
And I mean, I remember when it first came out, I mean, I downloaded the app because I was like, this sounds cool. And also, I mean, just like, I assume we all are involved in legal tech because we want tech to be able to help legal. And we wanted to do these things. So, I mean, I guess maybe there should be a little bit more skepticism or whatever, but I guess for something as big as that, I'm assuming I'm not the last line of defense, that it works, but, because I don't want there to be an Elizabeth Holmes of legal tech.
Yeah, well, it would make a great movie, but
yeah,
probably not. We'd watch it. All right, so I'm gonna go to my story, which probably some of us also covered this week, but if I can only find it here, the fact that Axiom opened a law firm this week in Arizona. This is, the Axiom is one of the longer established alternative legal service providers. And as I said in my story, now this week it's stepped into the world of licensed legal services providers, opening a law practice. It's not even the first one to do it in Arizona, but it's a significant move, given that it is a significant ALSP. And it potentially will help, serve as a proving ground for this whole idea of ABS licenses in Arizona and what they can deliver or not deliver. I think it's starting out kind of modestly in the sense that it's just two lawyers and two lawyers who are both coming from an established firm with a kind of a commercial business law practice. But they're talking about trying to disrupt even that a little bit, at least in terms of their ability to offer lower fees and flat fees and more package types of legal services. So I think that's really going to be an interesting development to follow over the next couple of years to see what they actually do. It is kind of interesting to me that so much of the original talk about loosening the licensing restrictions around the practice of law were focused on access to justice, and yet what we've seen in Arizona are a lot of these entities that are getting licensed as ABSs. They're not focused on serving low-income people at all. This ain't about serving low-income people in Arizona. This is about serving mid-sized to larger businesses that, in most cases, don't have their own in-house legal department or something like that. That study that came out. There's a study that came out. Lucy Ricca and the other guy at Stanford. I'm sorry, I'm blanking on his name. Looked at the sort of the data that came out of Arizona and Utah so far, and found that Utah's model was sort of much more amenable to the creation of programs that are going to serve low-income people, in part because it kind of allows different classes of legal services providers, not just lawyers working for corporations, but paralegals and whatever delivering legal services directly. So anyway, I think it's an interesting and notable move in the world of legal innovation, and the proof will be in the pudding on it, I guess.
Yeah, I mean, it raises a lot of the same issues we were actually just talking about with Do Not Pay, where, I mean, it has allowing these structures has a real potential to increase access to justice. But again, we need to sort of see how it plays out. And I actually think the protectionism argument is a stronger one here. Like, people that are against this, I feel like it's much more, I think there is a stronger argument that people who are against this is purely protectionism of the industry, is what I'm trying to say. So I'm very curious to see how it works out, and if it's successful, where it leads.
Yeah, I mean, Axiom, for all intents and purposes, is, it's already a law firm. I mean, it's
Right.
doing legal work, on an outsourced basis, and this really just kind of removes some of that the sham of not a sham exactly, but it just acknowledges what's really already happening in some ways.
I mean, we've worked in law firms, so we know how much of it is not being done by lawyers anyway. So yeah.
Right.
Yeah. And I will have to say, I mean, we do focus on low-income people when we talk about access to justice, and rightly so. But by the same token, there's a great number of small businesses, solo-owned businesses, and entrepreneurs out there who frankly, due to where they are in their business careers and lives, can't afford a lawyer. And if there are ways to reach that untapped market, which needs to be served, because they can easily be taken advantage of by larger businesses that are more well-heeled and have assets and resources, and stifle creativity and innovation on that end. So it's not unreasonable for Axiom to be looking toward that market, and it's not necessarily a bad thing. Although, yes, we do need to be focused more on low-income people who are even more disadvantaged. But in any event.
But are they focusing on small, like the small mom and pop stores? Or are they focusing on just smaller businesses that are like not Walmart, but like, maybe like a slightly smaller scale that maybe doesn't have the same kind of in-house resources?
I don't know if it's smaller. I don't think it's that small. I think they're looking more mid and large. They're looking to take a bite out of they're competing with bigger law firms.
Yeah.
In the
that's what it seems
application
like.
that they filed in Arizona, they said they specified, mid-sized companies that do not have in-house legal departments. But I had their chief legal officer on my podcast this week, and she described it as even higher than that, but not lower. I mean, going up even into the enterprise level, and almost as an adjunct. That Axiom could be an adjunct to this firm rather than this firm being an adjunct to Axiom, but that this firm could be doing some of the core legal work and could be then using Axiom as a backup support for other more sophisticated work or other more labor intensive work.
But if it's successful, even for those larger, I mean, even if they don't necessarily fully pursue the access to justice point, if they make the model successful, I think that has the potential to open up for other businesses under this model to actually serve those smaller companies, or those small pop shops, or the people that don't have money for lawyers. So I think it's a grand experiment that is more thought out than some of the other grand experiments we've discussed today.
Right. Yeah. And they have the resources to do that, to think it out and to execute on it and to develop it. I think that's part of the reason it's so interesting. So. Steve, law firm hubris. Something we've never talked about on this show.
A couple of articles, newsworthy events and announcements that came out that kind of caught my eye, that sort of are continuing examples of law firms that try to solve today's kinds of problems and concerns, particularly with younger lawyers and associates, by using thinking that they've used for the past 50 years. One was the announcement by Brian Cave, which is a fairly innovative law firm, that if you bill a certain number of hours over the year, they will allow you to take a vacation. They didn't say it that way, but that seemed to be sort of the underlying message, that you have to reach a certain number of hours, and then yes, you can record your time spent on your vacation, but let's face it, no matter how you shake that out, that's unbilled time, uncollectible time. When it comes to the end of the day, whether that's going to count very much towards your advancement, at least with the law firms I was with, it probably would not have. So it just struck me as sort of funny that a law firm is going to try to solve the work-life balance question and encourage associates to take more vacation by telling them to just bill more hours, then you can have a vacation. And of course, the catch-22 is, if you bill more hours, how are you going to have time to take a vacation anyway and still make the quota? So I thought that was a sort of an interesting way to use the billable hour matrix to try to dressed up as a guise to help you have a better work-life balance, and not to mention that the fact that it continues to emphasize billable hours as opposed to productivity and creativity and all those sorts of things. And then the other thing was the announcement, and I think Victor picked up on it too, the announcement by Sidley that the time you spend in the office is going to be a factor in determining whether you get a bonus or not. And it's interesting because I think one of the things that the pandemic showed is you can be just as productive and produce just as quality of work working remotely as you can in the office, but nevertheless, for reasons of control or what have you, we're going to demand that you be in the office a certain number of days a week. And it was interesting because the announcement was coupled with, we're going to ask all lawyers, quote, all lawyers, unquote, to be in the office. And my guess is that, if you're a lawyer at Sidley and you have a $10 million book of business, I don't think too many people are going to be concerned whether you're servicing that business from your beach house or from the office itself. But yeah, it just struck me that, in trying to measure commitment by lawyers and engagement by lawyers, particularly associates, in this sort of new world that we're living in. The law firms are kind of reverting back to get your what in the office, because that's one way we can make sure that that you are committed and engaged with the law firm. And it just seems to me like a core answer to where we are these days. So I thought both of those things were just, here we are, we've been through this pandemic, we've shown what we can do with technology and remote, and we've shown what people sort of need to have a fulfilling life, and that we're going to solve the problem the way we always have. Work harder, be quiet, shut up and don't complain.
I'm sorry, I'm glad I was muted because I just like sighed through your entire talk there and shook my head a lot. I mean, maybe I'm still too close. I mean, it's been over a decade, but I feel still too close to big law that I'm like, sure, like, no, they're not going to apply these rules to all lawyers. They didn't apply back. I mean, flat out when they required FaceTime, and nobody was allowed to work remotely, that never applied to the partners then. Like, it's they're finding new excuses to put in the rules that were always in place. And if anybody was going to undo what we gained through the pandemic in terms of remote work, it was going to be big law. And I'll stop now because I'm jaded about this subject and rant.
And here's the other thing, I mean, I would hazard to guess that nobody is going to become a partner at Sidley unless they have been eligible for bonuses as an associate, right? I mean, that stands to reason. And so who does that unfairly penalize? And I mean, let's face it, it unfairly penalizes women who are more often than not primary child care providers in a family and who need that flexibility that remote work provides. And so we're now continuing to perpetuate this gap in partnership ranks because, golly, so-and-so wasn't here as much as she was supposed to be. Well, she had, two children she was trying to take care of, and her husband was doing something else. And that's too bad. She didn't make her attendance quota. It's just, come on, guys. I mean, aren't we sort of beyond that by now? I guess not.
Oh, we were, and then we're back.
Yes.
Victor, you guys had a story on this related to this too this week.
Yeah, and I think we just picked up the other stories, but I mean,
the same
but
one.
I mean, we've been talking this on the show, right? Like this idea of like, okay, well, you have all these law firms, like 2 years ago, whatever. Like we were like, oh yeah, these firms, they have these really great policies. They're all saying the right things. They're all saying, oh well, we realize that a happy workforce is important, and if people can be more productive, at home, then why not just let them be at home? And then I think we're all kind of wondering, is like, is that real, or is that what they're saying now? And then when things start to kind of go back to normal, they're going to be like, okay, well, things are back to normal now, so you guys can come back to the office, and if you don't, then we're going to do this. And so I think, yeah, I mean, I don't think we can be too surprised by it, because I mean, I think it's kind of a natural inclination to be like, okay, well, we just want things to go back to the way they were because it worked for us back then, and now the pandemic's pretty much, I mean, it's not over, but I mean, people are living with it now, and so it's kind of like, well, let's just go back to what worked for us for decades. And especially in the law firm world, it's very much like you have to make sure you're seen at the office. You have to put in the FaceTime, you got to put in the time with the partners, got to put in the time with your mentors, the time with the senior associates, whatever. And if you don't, and if you're not seen there, it's almost like you don't exist. And so yeah, I mean, I don't think we can be too surprised by this, but it's still kind of funny to kind of juxtapose that with like what they were saying like 2 years ago with like it's a new world and blah blah blah, with all these tools that we have at our disposal and everything. So
well, and I think go ahead, Steve.
The worst of all worlds that we could end up with is law firms that profess to still believe what they said 2 years ago, but when it comes time for an associate advancement or partnership decisions, they revert back to the old analysis that they used 3 years ago, which, everybody's expectations may be different. And now, it's the sort of the unwritten rules that float around a lot of partnership and associate advancement decision-making. Sorry, Greg, I didn't mean to interrupt.
No, sorry. I was going to say, well, one of the things that's kind of hovering, and law firms, I think, have predicted 6 of the last 2 recessions. And so everyone is predicting doom and gloom for the rest of the year. You're seeing layoffs already. And so, and you're going to see more. I'm already hearing of more firms come February that are going to be laying off some more people. and everyone's puckering up, and when you do that, you go back to what you know, and what everyone knows is, well, we were successful when we were all together, and therefore we're going to have to do that. And I think, and I posted an article on that, in that it talked about high performance culture. So yeah, you can make, you can be very productive, but there's also high commitment culture, which means that you can be committed but connected as well. And it doesn't mean that you have to be in the office, but it means that you need to have a structure that admits that, okay, some people are going to be doing this and some people are going to be doing this. We've got to figure out how it is that we run this firm or manage this firm to run in an environment where you are going to have this hybrid remote environment. It's just, trying to get everyone back in the office is like trying to, shove the toothpaste back into to the tube. It's gone. And to believe this, and then, again, and I think we saw we had 2.3% GDP growth yesterday that was announced. So, this big boogeyman of a recession that's supposed to already be on us isn't on us yet. And so I'm just, I think, again, surprisingly, law firms are overreacting to how they think they need to manage their people.
Yeah, and it's, the notion of having somebody be in the office just to have them be in the office is just, so wrong. I mean, I don't think most associates, and most even partners for that matter, don't mind being in the office when there's a need to be there. And so if you let partners running the teams and practice groups running the teams that make decisions about when somebody should be in the office or when they shouldn't be, it just seems to me like that's a whole lot better.
And this is
way
just
of doing things than it is just to say, all right, everybody come back down here whether you need to be here or not. Which, I mean, I practiced law for 35 years. Most of the time I was in the office. I went to work. I got my cup of coffee. I went to my office. I closed the door and I worked.
And this just feels like a more egregious extension of the conversation we've had in the past about how, sure, there are benefits to hybrid going back in. There's training benefits, mentorship benefits, especially for younger more junior attorneys. But that's also, once you get to dictating the exact days they have to be there, and then now even further tying their pay and their success or their bonuses or any of that to it, that's not about the benefits of in-person anymore. That's purely a power play, in my opinion.
Mm-hmm.
Well, now that we've all been calling Joshua Browder to task for accountability, now Joshua Lennon's calling Greg for accountability here. He wants to know where you got that data for that claim about law firms predicting recessions. So, see, now we're all going to have facts to back up what we say. Now we've ruined it for everybody.
That's why I'm a blogger. I don't need facts. I just need to print stuff.
It's all true as long as you run it through ChatGPT.
Yeah, and you're confident. I'm very confident in it.
Right? Well, it's like alternative facts, right? I mean, it's like, yeah, like, well, you might not agree with it, but these are my facts.
Exactly. All right. Anything else good of the order? Anything anybody wants to raise or highlight or talk about? Then if not, we will wrap up for today and be back next week. Thanks to everybody for attending. Greg, thanks for joining, and I've got to go subscribe to your new daily podcast right now, and thanks to everybody in the audience for listening. See you next week.
Have a good weekend.
Bye, everyone.